among the many who would rather be at the International Symposium on Economic Crime in Cambridge than sitting in my office as I am today. The symposium is the 38th in a long series then of symposia, and it is a remarkable series of symposia. Each one of them are remarkable, but together they are without any equivalent anywhere. And it's the 38th. I took part, I think, in the 36th as my first symposium, and I've been at every one since then. They started off, and they are still an initiative by Professor Barry Ryder. And when Professor Ryder started, when I came the first time, it was an interesting mix of regulators, lawyers in private practice, financial institutions who were regulated, and people who dealt with financial crime one way or another, as investigators, as lawyers, or as judges. Now, that group of people is still there. You know, this is the original constituency, but different other categories have been added to it. For instance, central bankers. When the symposium series or symposia started, there was very little interest among central bankers. Financial crime, money laundering, etc., was for the police. It was not for central bankers. That was their view. That changed, and it was quite dear, quite expensive, and awkward experiences that central bankers made because they had this attitude that financial crime, fraud, was not something they should be involved with. Today, central bankers are very important in their way that they, through banking supervision, prevent and deter financial fraud. And the group of people who have been added to different categories that have been added to the symposium participants are many. And one of the remarkable aspects of this symposium, of this series of symposia, is the way in which Professor Ryder has managed to keep not only the original constituency, but all these other categories of professions, to keep them within this very broad tent of the International Symposium. This year, the topic is economic crime, who pays and who should pay, and it is prevention and discouraging. How can we use the law and the institutions to prevent or discourage economic crime? It's an obvious question, but it is asked in this symposium in ways which are novel. It sums up the knowledge and the experience, and it poses some very, very challenging questions. And when you are preventing or discouraging or deterring, it's not enough to look at who actually commit these crimes or who facilitates it in a very direct way, but you have to go beyond. You have to look at the whole legal system and the different duties that the institutions involved and individuals have. And not the least, you have to look at the remedies for breach, and then not only remedies for economic crime in a narrow sense, but remedies against breaches of duty to prevent, to discourage, or in other ways contribute to the fight against economic crime. And I was supposed to speak in in two different programs within the symposium. I was first going to speak on Wednesday on combating corruption and financial crime in partnership, international stability, security and development. Now, of course, there will be other people explaining how detrimental financial crime is to so many aspects of development and of international stability and security. I, of course, was going to lend my support to that, but I was also going to say something about the abuse that we see today, the abuse we see that some countries are guilty of, in the way they abuse what we have got in place in terms of international enforcement. And obviously, Chinese issues were going to come up one way or another in this symposium. My angle, there are many others which would be discussed by others, but my particular angle in this symposium would have been to focus on well, for instance, the ways in which the United States are using international legal cooperation to enforce its own sanctions legislation. And that's the first internationally controversial measure in relation to Huawei, perhaps, the criminal prosecution in the US of the chief financial officer of Huawei in the context then of US sanctions legislation. And she was arrested in Canada. And as far as I understand, she's still on some kind of remand in some kind of detention in Canada, awaiting the judicial determination of the US claims or demands for her extradition to the United States to face trial there for breaches of different aspects of US sanctions legislation. Now, this puts international collaboration under pressure, and it is extremely difficult when large countries use the international system we have for dealing, for instance, with other economic crimes, when they use it in this particular context of pursuing such a political case against Huawei. It's linked, I understand, to not only to a normal legal process, but also to political initiatives. And of course, it fits into a general set of measures by the US in its conflict with China. And we have other aspects of that. The way that security experts one day have said there are no particular security issues relating to Huawei's 5G network, and then they change their minds. It looks like by then acceding to the political wishes of saying the opposite. That's been the case here in the United Kingdom. I say here in the United Kingdom, that's where the symposium was going to take place. I say this from my office at the University of Oslo. Now, I find the Huawei chief financial officer detention in Canada extremely, extremely problematic. We must at all costs avoid the international cooperation relating to economic crime. We must prevent at all costs that it's being contaminated by the trade wars that states sometimes engage in. And indeed, we are at the height of such an engagement in a trade war right now. We must, when we're dealing with economic crime, stay outside of that and try to preserve the autonomy of the criminal law, of regulation, of different kinds of instruments which are there, not to promote the different warring parties to an economic trade dispute or trade war. I think some of the discussion about TikTok, as we have seen, and the references to the Chinese legislation saying that employees have a duty to hand over information to the intelligence or security services. As a matter of fact, we are not in very different situations in the US, in the UK, or for that matter in my country. If the intelligence and security services come to you and ask for information, I think most of our big corporates, small corporates, perhaps even more, they would accede to the demand. So the idea that we have issues in this context, which are so different with China, I have not seen any real support for. I'm not convinced at all. Now, this is not about political free expression. It's not about human rights in China. There are many issues there. But what we are talking about here are different ways of abusing an international recognition and abusing it to pursue aims in a trade war, which is pretty remotely connected, if at all, with, for instance, the human rights issues which are brought up in other contexts. Now, having said that, and of course the consequence of what I'm saying is that international collaboration in this field are under an enormous pressure right now because it's being abused. Having said that, I think there's still much room to continue to develop international rules, to develop international collaboration, but again then aiming at where it's possible, as broad multilateral participation as possible. This is not then against individual countries making an agreement about collaboration in a particular field, in a treaty, in a memorandum of understanding. That will go ahead, but one must at the same time use the multilateral approach where it is possible, and one must not on this bilateral level enter into agreements which threaten the broader multilateral initiatives. Now, very often when people mention multilateral initiatives in this context, it is to stop bilateral collaboration to go on. That's not my point. It is what you use the bilateral collaboration to. Do you use it to undermine the international legal system when it comes to acceding to requests for extradition, etc., in the context of judicial legal cooperation? That's a different matter, and that's what we must avoid at all costs. And where it is for civil society, people like us, to say to our home state authorities, stop it. Don't go on abusing international legal or judicial collaboration the way you have started doing. Now, that was one of my topics. Another topic, which was to be discussed on Thursday, the 9th of September. The topic is improving the flow of information between public and private actors in discouraging, disrupting, and bringing to account economic criminals. And here, again, one is dependent on international collaboration. And in order for that to be recognized in the domestic legal systems, one needs to agree in international treaties. For the practical purposes of actually making use of the treaty obligations, one needs further agreements in memoranda of understanding. One needs to work out practical arrangements, because in many instances, it's not very strongly in the interest of the authorities in a country where the criminal has absconded, or where there's an important part of the network or the system that the criminal uses. It's very often not in that host country's interest to assist with investigation if the detriment, the consequences of the criminal activities are seen in another country, and that's typically that country that then starts investigation and prosecution. So there, it is of great importance that one has systems which are so clear, which are so automatic, that there is not much discretion left to the countries which receives the request, so they just can go on and accede to it without thinking about prioritizing against other what may seem more pressing issues in their planning of their work. So again, it's important that one manages to deal with this at an international level, and we'll get this to work in a practical sense. I was going to look at, in particular, in my paper, how one can give effect to public law duties in a criminal and in a civil context. Now, of course, when we are talking about prevention and discouraging, it is very often risk-based. So you would say a bank has to assess the risk, and it has to take measures to mitigate the risk. So it gets this duty of care, which is often very clearly defined, although at the fringes there will be discretion, and it would be a question of the models that the bank, financial institution, law firm, whatever it is, a question of how far they want to go in terms of making the prevention and discouragement effective. Now, what is important then is that you have a set of remedies following very, very closely. You can't operate in a system where you establish these duties as public law duties or self-regulatory duties, which then are not enforced, or which depends on the enforcement of a regulator within the jurisdiction of the financial institution, law firm, or whatever entity it is. So there you have to, in this context, then first of all establish the duties, the duty to assess the risks, and then specific duties in order to take the consequences of this risk, and to create frameworks which prevent and discourage that risk or individuals for allowing this risk to manifest itself. Now, among the remedies we have are, of course, a whole set of civil law remedies, which you must make open, you must make available for the people who suffer the detriment. For instance, in another jurisdiction, you must open for different kinds of group actions. You must facilitate the effective enforcement through civil remedies. And this is an area where we have many good models, but we also have many problems. So, for instance, in the United Kingdom, we have for many years have had the issue of what are the civil law consequences of duties which are primarily developed in European regulation. Even if that regulation is transposed into domestic regulatory rules, there's always a group of lawyers, some on behalf of the clients, but also academics, who argue against giving civil law effects, for instance, to regulatory duties. Now, those battles are partially fought out in the courts, but to a larger extent, they should be resolved by the legislator. The legislator should make clear that the breach of regulatory duties actually lead to civil consequences, so that there could be huge financial liabilities, which will give the strongest inducements to the regulated entity to prevent and discourage. Now, as we all know, this develops. The regulatory system has developed quite far in the last 15 years, but we still haven't resolved the issue of civil liability. And in the UK, some will now term this as a conflict between EU law and domestic law. That's just too simple, because most of the UK regulation will continue in the same form, with the same duties to prevent and discourage. And you still will have the problem of what are the civil consequences? What will you have to pay in damages, in compensation, for instance, and the whole raft of other civil remedies. And it is quite surprising, if you look at it with a fresh, if you take a fresh look at it today, it is quite surprising how unclear and how uncertain many of the remedies are. And uncertainty is not always bad, but in this area, it is important to make very clear what are the civil consequences and how can you get the compensation that you should get in cases of breach of the regulatory rules. And in my paper, I would have gone through a number of instances, looked at the number of regulatory duties in the UK and in other European countries, and I would have shown some different approaches taken by courts in terms of giving or not giving effect in civil law. Now, this is something I hope I will be able to come back to. I will certainly write out my paper, and I will make that available to you. And I know that most of us really would have liked to be there at this symposium, which we now cannot. But I welcome this opportunity to say something more general about my topic, and I only hope that we will very soon, and at least that we next year will be able to return to these topics and have this full discussion in the meetings of the symposium, which always provide you with a new angle, a fresh angle, and makes you go away with inspiration to continue your work. Well, I hope to see you very soon, at least next year. Thank you very much.